I'm joined now from Waterhouse Mediation by Michael Waterhouse. Michael, welcome to the TER podcast.
Thanks very much for having me, Cameron.
Now, in the world of education, you've had a somewhat more unique perspective and career. Can you tell us a little bit about your background in education and the law?
Sure. Well, perhaps if I go backwards in time a bit, until about 2.5 years ago, I was General Counsel at the Education Department in New South Wales. And that role, or its predecessors under different names, I was in for approximately 20 years. Before that, I was in a policy role in the department, negotiating Commonwealth-state relations, and at various times I was a political advisor and chief of staff for the education minister. So I've got a range of different backgrounds, and now I've come to the role of being, as you announced, a mediator, and I'm mediating legal disputes and various disputes which I would describe as kind of asymmetrical disputes between, let's say, organisations and individuals. And I'm also giving seminars for schools on education law issues like the ones we'll be talking about today. And I'm still a lawyer, although I'm not doing as much legal work as I once did. So in the education department as a lawyer, we had the Legal Services Directorate, which dealt with all of the legal issues of the department. We also used external law firms to help represent us in various litigation and so on. So quite a complex area, and we dealt with all of the legal issues that a large government department might have to deal with.
Oh, I'm sure there are many stories you cannot tell. But
yes,
what we're going to do...
Privilege and confidentiality, very important.
Yes, I can imagine. What we're going to delve into today is this topic that is still currently quite hot in education about the rising generation of artificial intelligence technologies and their potential impacts on education, but obviously looking at some of the legal consequences. Now, in the context of us recording this interview, it's currently early December at the time we're recording. It's only in the last week that the federal government have published the first official version of their guidelines and principles for using AI in education, with talking about principles like it must be to enhance teaching and learning, and student well-being must be factored into people's thinking about use of AI and things like that. And so we're going to talk about some of the legal issues that arise from some of these principles, and drawing on your experience of education at the law, looking at some of the places where teachers, schools, systems just might need to be aware of what potential legal complications may arise from even well-intentioned following of some of those principles and policies. So to dive right into it, one of the big ones, and one of the first things that has arisen from the federal government's principles is the idea of duty of care. You know, they talk about their principle of human-centered use of AI and of fostering student well-being. So why don't we start there? What do you see as some of how does the rise of AI potentially affect duty of care for students?
Sure. Well, it's a very important question to consider for teachers and for schools. And I suppose if I could just make some broad general comments first. First of all, I think at one point you said, "Oh, we're still interested in it." Well, I think there's going to be interest in AI for a long time to come. I think we ain't seen nothing yet, and I think it's very hard for us to know where we are in this kind of potentially exponential curve or this tsunami. And I think that means because of rapid change, we need to be thinking about these questions very regularly. And the answers that we provide today, or the thoughts we think about what might go wrong today, we may well think in 5 years' time or less that, oh boy, we were naive back then. We just didn't realize what was happening. So I think we need to be revisiting and rethinking these all the time. So that's the first general caveat I'd like to say, so that if you're listening to this podcast in a year's time, it might be very out of date. The second thing I would say is that there are not yet to my knowledge, new laws passed. I saw there was a report that the EU is trying to enact a law, and it's having a lot of difficulty in getting its members together to support a common law, and they've been negotiating it for 3 days and have now taken a break. The UK have issued a white paper, and again, these are I don't know the content of the EU law because they haven't passed it, and the UK one is a similar broad framework, but perhaps in more detail than the Australian one for schools at the moment. But without any laws being passed, there's a body, all of the existing law that we have governing Australia applies to new circumstances that will fit into that law. So if we take, for example, the duty of care, which was your question, and in the national framework, that's referred to in, I would say, point 2, which is human and social well-being. Generative tools are used in ways that do not harm well-being and safety of any member of the school community. That's both teachers and students or anybody else. Diversity of perspectives, that might relate a bit more to discrimination and so on, and human rights, individual autonomy. Again, that's probably more about discrimination. So that 2.1, using AI in ways that don't cause harm. Now, teachers will be aware, probably from their early training, and probably they've heard it again and again over the time, that a teacher has a duty of care to their student. Now, in a practical sense, it is the school authority. In the case of a government department, that would be the Department of Education for government schools. In the case of non-government schools, it might be the system of schools which owns the non-government schools, or it might be the individual school. So it might be the Catholic diocese, or it might be the trustees for a particular school board or whatever. And it's that school authority which has the legal responsibility. And in New South Wales and probably most other states, the employer has a duty to indemnify the individual employee against that liability. So it's the school authority that has to take it on, but they need to enact that through their employees, their teachers. So teachers have a duty to take reasonable care for the students who are in their care. And that's just a very solid, basic common law principle. Now, the question here in AI is, well, what counts as reasonable care? And reasonable care is basically avoiding reasonably foreseeable harm. And what counts as reasonably foreseeable? That sounds like a kind of nebulous concept. Reasonable, it could mean anything. Well, it's what a reasonable person would think. So the question is, would a reasonable person expect a teacher to do something to protect a student from harm in the circumstances in which you find it? So, for example, if we talk about the impact of AI, we're already aware that there's responsibilities for schools to have policies against cyberbullying. And cyberbullying is something that can be potentially made worse, or more effective cyberbullying by the use of AI. And I've seen some examples around the world of that. For example, in Spain, there was a case of some students who took photos of their fellow students and used an AI tool to place them on a nude body and then send those photos around to schools in a form of, cyberbullying and sexting kind of thing. So that was quite a serious one, investigated by the Spanish police. I checked it; it wasn't a hallucination of the AI. It was a real case, and those kinds of cases where the deep fake technologies can be used to create false information that is then used for cyberbullying purposes against other students is something that could be an example. Now, you might say, what's the school's responsibility for that? Well, in New South Wales, there's a ban on the use of phones. So in one way, they're removing the possibility of that happening in school hours. But nevertheless, the law is unclear as to whether outside school hours, if there's cyberbullying between members of the students that, let's say, arise in the context of a dispute at school, that then is continued overnight at home in their bedrooms and then comes back at school. If the school becomes aware of that and is not doing anything about it or has no policies to prevent it, then it could be liable for failure of duty of care, because it has brought the students together, and the students, in a sense, because they are students, is the cause of the conflict between the students. So that's one of the examples. Another, again, potentially related issue is the issue of self-harm. And in my view, self-harm, it's kind of anecdotal. I wouldn't say this is a scientific conclusion from my own perspective, but I think self-harm has become worse in recent years because of some of the ways in which social media tools have become addictive and so on. And again, AI may add to that. The question is, can those things be prevented? How does a school become aware of it? Does it have policies and practices that will, allow students to report potential harm or to get help if they are addicted or that kind of thing? So anyway, that's a kind of preliminary answer to your question.
Well, there is one thing you brought up there that I think is also interesting to explore from sort of a legal and an employment and even a policy perspective. We're talking about a federal government framework for the use of AI, but as you indicated just there, the federal government is not the one that employs people or that has the obligation to have these policies in place. It's state governments, it's Catholic systemic structures, it's independent schools and their governing boards that have to have these policies in place. So with these principles that have been published by the federal government, are they basically some nice ideas that state governments and that other education employers will be expected to try and incorporate into policies? And if you're talking about it from a perspective of who has the legal obligation, how does that work in the dynamic between, say, a state government employing thousands of teachers and a federal government who don't?
Okay, good question. So, looking at the policy, it is signed off. It's not a federal government policy alone. It's I'm not sure if it's the actual. It's the National AI in Schools Task Force, I think, is what it refers to, and it's signed off by all of the state education departments, as well as the Commonwealth Department, by Independent Schools Australia, National Catholic Education Commission, a range of other bodies that are all national and state or individual systems. So it's not just a Commonwealth government policy, it's all of those bodies have come together to agree on this framework. That's the first point. Second point is, as you rightly say, with some small exceptions, the Commonwealth government is not the employee of teachers. It's each of the state governments or each of the independent school bodies, whether it be individual schools or systems of schools, who are the employees. Or there are different arrangements for different systems, who are the employers, I should say. So generally speaking, it will be the school authority. So I don't think the Commonwealth is a school authority. There may be some individual Commonwealth schools. In rare cases, there might still be a school in the Jervis Bay Territory or somewhere like that. And it is the owners of the schools, which will be the state governments or those non-government school bodies, who are charged with the legal responsibility.
And to your understanding, is there any significant difference in the legal approach to issues of duty of care and self-harm that are taken by particularly the large education employers, the different state governments or the different territory governments or the different dioceses of the Catholic system, for example? Or do we have general kind of agreement of the legal accountabilities of education systems around the country?
As a broad generalisation, the answer to the last question is yes, there is basically the same law across Australia. That's for two reasons. One is that the common law, so the judge-made law of our land, is one national common law. The ultimate court of appeal is the High Court of Australia. There was, for example, only a month or so ago, a very significant High Court case that came out of a It was actually a church-related case, but would apply equally to schools. In New South Wales, it was about the limitation period, which after the Royal Commission into child sexual abuse was abolished on their recommendation. And basically they said there's a new framework where there is no limitation for a case of that kind. So that's a case that would apply right across Australia, a common law personal injury case for civil litigation for personal injury. Same law across Australia. That's the main thing that gives rise to the duty of care. The other part is the work health and safety law. And although that's not completely identical across Australia, there is intended to be a common framework where basically each state enacts the same law and the Commonwealth enacts the same law. So the law is generally, there may be some states who haven't enacted it, but I think most of the states have. So the obligation of an employer to provide a safe place of work, both for his or her customers, people who might visit the site, and employees. So again, that applies as a duty both with respect to staff and students. And that's, again, very common across Australia. So basically the answer is yes, with all that qualification.
Okay. So going from that issue of duty of care, one thing that's all increasingly contentious in the age of social media and education is managing privacy and obviously cybersecurity. But the example that you gave of someone using AI to create images of a student's head on a nude body obviously goes into people's right to represent themselves or to have their images and data private. I mean, how do you see AI? What other potential issues with privacy and security of student images and data do you see arising out of AI in education?
Yeah, well, that's a very interesting one, and I think the courts need to. I mean, there haven't been any cases that I'm aware of that have come in Australia about AI and whether someone has a right to protect their image in that AI sense. I believe that there's a national law which is administered by the E-Safety Commissioner, and basically it prevents cyberbullying both in relation to students and adults, and in terms of sexualized kind of conduct like sexting. I mean, it was crafted for the circumstance where, let's say, an angry ex-partner takes private images and publishes them as a kind of revenge porn, as they have called it. It's designed to combat that, and it creates some serious offences about that. And I think the interesting thing will be if something isn't in fact an image of the person, but is something very close to their likeness, whether they will have the capacity to combat that. I suspect they would, but there might be sort of marginal cases. I haven't looked deeply into that law, and I could do some more homework on that. But I suspect there'd be marginal cases where the image is similar but not the same, and where is the cutoff point for whether an image is like another person or not will be difficult to determine. I think that's one of the areas where the courts will have some new principles and new thinking to be encountered. In more generally in terms of privacy, so if we're talking, I mean, that's kind of protection of someone's personal reputation, and when it comes to reputation, defamation might also be a factor, a law that comes in to protect that, or to allow a person to take action to someone who has published an image of them. You might recall, maybe the younger listeners might not recall, but perhaps about 25 years ago, there was a famous case of a footballer who was taken a photograph in the shower, a slightly fuzzy photograph, but he took a defamation action against the newspaper or magazine that had taken the photo and published it based on defamation, where his claim, and I think he was successful, was that his reputation was damaged because it would be taken by the readers that he had given permission to have a nude photograph taken of him and published, and that wasn't true. So there are those kind of things that you could take as a way of protecting it. But defamation is not a very, as you've seen by some of the famous defamation cases that have been around in Australia in the last year, one of which is ongoing at the moment. Defamation is a very clumsy tool to try to fix this kind of problem. So again, the e-safety commissioner tool might be better, but
Or perhaps, sorry, you mentioned the 25-year-old case about the footballer for defamation, but when we talk about image manipulation and some of the things we're talking about now with AI, the case that comes to mind for me more recently, I think it's about 10 years ago, when the comedians that were part of the Chaser team published an image of journalist Chris Kenny engaged in a sexual act with a dog, and he, obviously it was a manipulated image,
right,
and he sued them for defamation, and they ultimately settled before it went to court.
right.
But the idea of manipulated images coming into defamation, I think that was a case where the comedians were trying to push the boundary of what constituted satire and fell under the laws for satire and commentary, and ultimately came off second best.
Yeah.
But this is a case, the things that you're talking about with AI and image manipulation, that's one case that there seems, well, you couldn't even say there's legal. Here's a legal question for you. If it's settled before going to trial, that doesn't technically set a precedent, does it?
No. So the precedent is a decision by a judge of a Supreme Court or above, probably you would say, that is authoritative and has carefully considered the legal issues. Normally, courts of appeal or the Supreme Court or the full bench of the federal court or the high court would be the kind of decision. So a matter that's settled out of court, normally that's done without admission of liability on either side, and often the results are kept confidential unless ordered to be released, as has occurred in the recent case I referred to.
Mm. So, but then beyond those issues of defamation and image privacy, I mean, there's also student data privacy.
Sure.
And, again, at the time that we're recording this, there've been some, rather concerning exposures of ChatGPT, and someone was able to manipulate the prompts of ChatGPT to reveal private user data that was supposed to be secure.
Right.
So how do you see that as an area
Okay,
of
so
concern?
that is a real issue. So just to give you a quick summary of the principles of privacy, there's quite a lot of them, but essentially it's about protecting personal information, and personal information is information that from which you can identify the person. So name, email address, maybe social media account addresses, photographs, DNA, medical information, etc. So anything that's about the person or from which you can identify the person. And with that, you have to seek permission for it. You have to hold it securely, and you have to use it only for the purpose that you've collected it. And you can only release it elsewhere if you've got a lawful excuse. So it might be for law enforcement purposes or for a court order or something like that. So that's the general set of principles that apply in protection of privacy. Now, if you're saying that, so privacy law, there's different privacy laws that apply to different levels of schooling. So there are state privacy laws that apply to government schools. There's the National Australian Privacy Act that applies to non-government schools and to private companies. In the case of ChatGPT getting the information and then someone, let's say, tricking it into revealing the information, and for a person who's not authorized to get that information, that would be, in my view, a potential breach by ChatGPT of the privacy law, and the Australian privacy law would apply to it. Now, from my general awareness, it appears to me that if schools are going down the track, and some are, of using ChatGPT or any of those other large AI, generative AI models, they will need to be doing so with some kind of agreement with a company that takes responsibility for the privacy. So, for example, Microsoft is the main owner of ChatGPT, and it's flogging the latest version of ChatGPT in what they say is a secure and encrypted environment, so that both businesses and potentially schools can rely, presumably, on the contractual obligation of the company, whichever company. I'm not promoting Microsoft, in order to keep the data secure from outside hacking, and to make sure that it's not vulnerable to release, and to prevent some rigorous systems to prevent abuse and cyber hacking and those kind of data breaches that we might have seen, like, for example, the recent one with Optus. Now, I think that the issue is this, in my mind, that there's so much competition, as I understand it from media reports and so on, between these companies that are going forward and they're wanting to get out as fast as possible and to roll out their things and to automatically embed the AI into their systems. There's a tension between the rapidity of that kind of development and their processes that they have in place that they've probably evolved over quite a period of time to ensure their security. Is there a tension between those sort of things? And that will be a difficult thing for a school or a school authority to be sure of, that the company that they're dealing with has those measures continuingly able to be guaranteed. Like, for example, my impression generally is that the major companies like Microsoft and Apple and Amazon and so on, who have data warehouses and have kept data, have developed over the last 10 years or so pretty strong controls around that. The question is any of that compromised by the speed of development of all of that sort of thing? I think that's real. So that's probably not a question for individual teachers, but it is a question for how the privacy is dealt with by systems. From an individual teacher point of view, the question is, are they collecting information? Are they simply encouraging students to use tools that might be collecting information? I think it's more a question of warning students, warning parents, getting permission from students and parents if they are using third-party tools, and knowing what to do if they do become aware of a data breach, who to contact, how quickly, who to make known about it, and how to stop it.
And so I suppose, for the perspective of the individual teacher, it seems to me like the main consideration, especially at this relatively early stage of AI's being picked up and used in education systems, is until your employer signs off on or endorses a particular product or model, just be very careful of what information you feed into it.
Yeah.
I mean, I've seen stories on social media of teachers using AI to assist with report comment writing, for example. Well, to do that would involve feeding in personal information about students, maybe not identifiable information, but I suppose teachers need to consider what information that might potentially identify a student you are putting into the system that may actually be too much or go beyond privacy restrictions, until your employer says, this is the tool we're using for that
so
purpose.
If you're putting, I completely agree with what you say. If you're putting information into the current publicly available ChatGPT, I have no idea who could potentially use that information. I'm not quite clear whether my impression is that the training can keep going on with all of the information that's in the system, including everything that's being put in. So that, part of it being free is that it helps the ChatGPT system train itself to respond more favorably to the kind of requests it's getting from its users. Now, even if there is anonymized data put into a system, a 8-year-old student with, an 8-year-old female student and the circumstances and this, that, and the other, it may be possible, because of various other things that are not personal information but are somehow still associated with the individual, that the information could be triangulated. And whether an AI model could, through the right kind of prompting, be coaxed into triangulating and identifying an individual is, something that's unpredictable to me because of what I would say is there is a kind of lack of transparency of exactly how the tools can work. I think those models seem to be having the intention, and if you try to do nefarious things, like if you try to do something that looks like it might be cyberbullying, it will stop you. If there are certain things, it will stop. I don't think we should be talking about that. Let's talk about something else, what the model will say. So it may stop you, but I haven't experimented and see what it does if you're trying to coax that kind of thing out of it.
Okay. Well, it sounds like, as you said at the beginning, it sounds like this is one of the areas where there's still a lot of development and a lot of consideration to be given to policy and legal ramifications. So I wouldn't mind moving on to the application of AI that probably is most front of mind for teachers, which is its impact on teaching and learning practices, particularly to do with assessment integrity and to do with things like authenticity of work. And obviously, when it comes to assessment, the issues of cheating and plagiarism come into play. I've seen some hugely varied policies when it comes to AI in education. And just to tell a couple of anecdotes, like I know of one university, for example, that has just fully embraced AI supported writing for students. And other universities are choosing to implement, very strict use of Turnitin AI detection, even with its identified issues with actually identifying AI writing. So when it comes to classroom teachers, and I'm thinking particularly of the highly litigious experience of matriculation exams in year 11 and 12 and the needs for assessment authenticity around those, where do you see some of the potential issues arising from AI that teachers might need to be aware of?
Yeah, well, look, I'm sure there's been a lot of educational experts, and I know you talked to some previously on your podcast about possible avenues for dealing with this from a teacher's perspective. So, I mean, I guess that as you've said, I've seen at least one university where the tutor, and I think it's in marketing, says, I'm going to be expecting you to use AI, and I'm going to be expecting you to be doing very well at using AI and to be expecting a much higher standard than I would have in the past because you have access, and I'm going to be expecting you to show me how you've used the AI and to show me how you've edited the AI and things like that. So that's one pathway. Another pathway, of course, is to go down paper and pencil again. I guess there's a spectrum of options in between based on considering what it is you're really trying to assess. So I guess it does put pressure back on teachers to think from first principles, what is it that they're exactly trying to assess and teach and so on. And, I certainly feel that there is great opportunity from AI from a teaching and learning and the individualization of student learning. I'm learning languages. I'm learning a number of languages, and I've found just asking the ChatGPT to be my tutor in Spanish or that sort of thing, it's fantastic. It's very quick. It can give me some good examples. It's not too boring. It's a way of practicing skills. So anyway, I think I think there's a lot of benefit there. But then when you come to cheating, there are already other examples of online exams, for example, and for example, the Bar Association tests use online exams, which they have required people to put on special software on their computer for the purpose of the exam, and they block out everything from that software, and they know that everything you've put in is you don't have access to the internet. It'll make sure you don't have ChatGPT on your computer. And
and those kind of lockdown browsers are the same things that get used for NAPLAN online and for the online tests that are increasingly being rolled out.
That's another sort of thing. All right, let's say are there legal issues out of this? So I think there are legal issues in the sense that cheating and plagiarism are something that are morally wrong and for which there is student disciplinary rules. So, for example, under the New South Wales Education Act, there are student disciplinary rules, and they include things like not cheating. In the New South Wales setting, the NESA, the body that implements the HSC, has policies of requiring people to assure things that they are all their own work. So the question would be, is if you do the kind of assignment that you have done to date, and you could just put an essay question into ChatGPT and get them to write the essay, and then perhaps manipulate it a bit more to say, say a bit more about this, give me some examples about that, use the ChatGPT to edit its own work, and then and now dumb it down so it's a B student, not an A student, and it has a few errors in it. That might be a way in which it's not all your own work. I guess the overall question with plagiarism and cheating is about student discipline. And so, as with traditional student discipline issues, schools need evidence on which to base a decision. They need to give students procedural fairness. They make a decision on the balance of probabilities. If it's a serious consequence, they need to be comfortably satisfied of what happened. So, I'd be very cautious about accusing a student that they had engaged in plagiarization simply because, for example, a filter system said, there's, say, a 50% probability that this is plagiarism. I think you might want, you'd certainly want to give a fair chance of a student to explain, well, no, I didn't do plagiarism, or, here's what I did, let me show you.
Well, when we think again about the individual classroom teacher and, school level management, especially again, acknowledging that caveat that we are in the very early days and that we don't know what the technology will look like 6 months from now or what policies might look like 6 months to a year from now. If a teacher has a reasonable suspicion that an assignment has been completed or partially completed by AI and is in breach of a school or a system assessment integrity policy, like here in New South Wales, we have the all my own work policy in years 11 and 12. Are they, from a legal perspective, better off letting it go than to potentially raising it without solid evidence?
Well, look,
if a student turns around and says, I didn't do this, and all they've got is a hunch, and I want to make something clear that, teachers deal with this all the time, copying and pasting from the internet, or while it's not as big an issue in high schools as it is in universities, even contract cheating and paying people to work towards completing an assignment for you. So it's not like the actual underlying issues themselves are new, but when it comes to, as you say, needing evidence of AI involvement and the AI detection technologies being quite, inadequate to be accurately relied on, what's the best course of action for a teacher who suspects AI has been used unethically but may not have that concrete evidence?
So, okay, let's say it's a classroom teacher and it's not someone who would normally have the delegation to make a disciplinary decision of a serious kind in relation to a student, like suspending them or expelling them or something like that. If it's a classroom teacher, and I think they have a duty, if they have a reasonable suspicion, as you say, and what counts as reasonable I'll come to in a minute, that a student has cheated, I think it's their ethical responsibility. It might even be considered their duty of care to raise it with the student, because there could be harm that follows if a student thinks that this is something that can easily be gotten away with. It's a bit like a parent whose child is obviously lying to them. You don't want your child to keep lying in future. You want to explain to them, look, it's obvious to me that you were lying. You've got the cigarettes in your hand still, or whatever it might be. And you might be wrong, so give them an explanation, a chance to explain themselves. And it's not necessarily that you move initially straight away to a punitive thing, but it's a question of a learning opportunity about what is reasonable behaviour. And I think that's within the individual teacher's remit. And that, the teacher has to think carefully. Last month they came with this kind of essay. It was very poor. This month they've come up with something that's so much higher that I've never seen a student improve so much in 1 month. And when I talk to the student, they can't explain how they wrote this. They don't really seem to understand the subject. My suspicion, every little piece of new information I'm seeking, my suspicion is confirmed. I'd be raising it and if it's a serious issue, then go up the hierarchy. And again, if the school, the school does not get in trouble, or the teacher's not going to get into trouble if there is a reasonable basis to make the allegation. That doesn't mean they've decided that the allegation is true, but to raise it with the student, I'm thinking that you might have cheated. What do you say about that? And give them an explanation, a chance to make an explanation. And I think that's a reasonable step for a teacher to take. Now, the ultimate disciplinary step is you might need a higher degree of evidence than simply making the allegation, if I could put, because the suspicion has arisen. Yeah.
Fair enough. Well, can we just then shift the focus slightly as well? Because teachers may also use ChatGPT or other AI models to assist with their planning program, resource preparation. So how does that potentially raise issues for teachers as well? We hear a lot, and currently there are lawsuits against some of the large creators of these AI models over plagiarism and over content being used to train their AI models that might have been copyrighted or not used in a legal way. So for teachers using the model, just like students may be using it to help with their assessments, where do teachers need to be cautious when using AI as part of their own professional practice?
So I think first and foremost, again, the issue of truth and accuracy is important. They should not be representing something as their own work that is not their own work. I think a good practice would be to say, this is generated by AI. So that, for example, if I've used AI to generate pictures to illustrate something, I generally label it generated by AI. And there is, I guess, a potential for legal action for misleading and deceptive conduct if a school or a teacher has held themselves out to be doing something and it's actually not their work, or it's something different, or it's false. So it's not just the question of false information, falsely holding out to be their own work. It's also the question of, is it accurate? So that checking. So you might use ChatGPT or whatever to do some research, to put some stuff together, to gather some materials, to give you an outline, to write a first draft of an email. All of these kinds of things might save you a lot of work, but it's still your responsibility to be the final editor and the final arbiter that what is said is correct. So you can't just do it and not read it and send it out. You need to read it. You need to check it. If there are hallucinations, and I've experienced the hallucinations. For example, when I was researching the cyberbullying issue a few months back, I asked for examples where people had been defamed by use of deep fakes, and it gave me an example of Elon Musk being defamed like that, and an example of Oprah Winfrey being defamed like that, both of which were false. Once I went to look in, there wasn't any such example, but it did give me a true example as well. So you've got to be very wary that anything that you're putting out to anybody else that they might rely on is accurate. You can't just outsource the accuracy problem to the ChatGPT if you're relying on it. Now, then coming to the issue of copyright, that is very complex under Australian law. There's various decisions as to how much human ingenuity has to be put into something before copyright arises in the material. Now, the issue of whether there's copyright material that's been used as part of the training of the large models, I think that's an issue that probably schools and teachers don't have to worry about. But the question of whether they hold copyright in anything new that's been produced, that is quite a difficult one to determine. There may not be copyright in that material. ChatGPT's rules say any users hold the copyright, but that's a question of if it exists. And it's still possible that it could reproduce something very close to something that is already copyright. And if it is, that could be a problem. But I think it's probably a problem for, I mean, I don't want to, there could be some difficulties there if something is very close to being just copying something else that's out there in the internet. So it's important to check that it is original.
Although I suppose, and please correct my understanding of this, but when it comes to copyright material, the primary concern is people commercializing someone else's work without permission or without authority. So for teachers in a classroom use, I know we have limitations on copyright, such as only being allowed to use a chapter of a book or 10% of a book.
Yeah. There's probably a good defense for that kind of thing in classroom use, as opposed to publishing on. So the statutory license for education providers, which applies to all schools and universities in Australia, gives that reasonable use of material for teaching purposes, as you say, a reasonable portion of a book. So what counts as a reasonable portion of something that's hidden behind whatever kind of search ChatGPT does is probably undecided at this point. There's a very good site for teachers who are interested in this copyright issue by the National Copyright Unit, which has a site called Smart Copy, and they have a lot of good advice, and I know that they've been considering, they're one of the signatories to this national framework, so I'm pretty sure they have been considering the copyright issues around all that, and they will have some direct advice for teachers looking to think about what are the copyright implications of any use they might make of ChatGPT, etc.
So I suppose at this stage, the teachers who might have some of the biggest concerns are those who might dabble in, producing content for sites like Teachers Pay Teachers or Twinkle, or actually commercializing some of their work as well.
That's true, or people who are, publishing textbooks or that kind of thing as well.
Yeah.
One final point to make, there's a general duty between an employee and an employer to be truthful to the employer. So if you were to use an AI to generate something that is sent to your employer or is representing something to your employer, that could be another area where you could get into trouble if you haven't taken reasonable care in something you have said. Let's say, for example, you're on playground duty and an incident happened and you had to write an incident report, and you just said to ChatGPT, write me an incident report about this thing, and it wasn't a true thing. That might be in breach of the duty of fidelity to the employer.
Right. Well, let's move on to some other areas that come into school practice and teacher conduct as well. You flagged the idea of information access, which relates to standard 3 of the framework about transparency.
Yeah.
So what do you see as issues here that teachers might need to be aware of?
Yeah, well, I think one of the things, certainly in government schools, so there's different answers for government and non-government schools. Government schools are subject to freedom of information laws. In New South Wales, that's called GIPA, Government Information Public Access, different names in different states. Those laws don't apply to non-government schools, but non-government schools are still subject to privacy laws where people can have access to their own personal information, a right to access. So in any of these kind of things, there can be a right to access. Now, what is it that there might be information that you've put into the system, even if it's protected in some kind of system that's not hackable, as we were talking earlier, where the information is manipulated and it spits out. I mean, if you were to using it to spit out student results in some way, this idea that of transparency, where what is the black box doing? And I know the fact that I recall various instances where the people, such as the owners of ChatGPT or the Google Bard, can't actually explain what it is that the algorithm is doing when generating answers. Now, the fact that you can't explain what's going on in the black box, I mean, traditionally you would have had a legal right to obtain the information about you in the government school system to obtain information about the policies and practices and decision-making rules that a school might have that affect you. And so I think that issue of transparency, I mean, I guess in one sense, you've only got access legally to something that can be given to you. But the fact that something can't be given to you, it's more of a policy than a legal issue in a way that there is a kind of gap there in what's going on, depending on how it is used. So I guess, again, I would make sure that teachers feel that they can explain what it is that is being done to information about students that is then coming out, if that's used at all. Otherwise, don't use it if they can't explain it. If is what I would say. Don't use it if they can't explain it. Now, it may be that really the responsibility is on vendors to explain it, and there can be reasonable explanation from them. But I think there's a reasonable expectation from the parent and student community that, in effect, decision-making about them, whether it be educational decision-making and so on, has some reasonable, rational, explanatory basis that a teacher or a school can give them. And that could be whether, disciplinary issues, could be marking and assessment issues, or it could be just, well, why are we going down this pathway? Why is it asking me to do this? So you want to be able to understand the educational rationale of anything that ChatGPT used as a tutor might do.
And this is a really interesting consideration in light of earlier conversation about privacy, particularly if the systems are built in such a way that inherently the way that the system's using the data can't be identified or controlled. Yeah. Can you actually control privacy in a meaningful way? That's a really interesting conundrum.
I think it's a potential tension between those two principles, both of which are desirable.
That does then raise the question about the use of AI, and one of the topics again you flagged here is decision making and procedural fairness. Like if we're not sure how the algorithm actually uses information beyond it being a privacy issue, what potential impacts does that have on, if people are, again, as we said, not outsourcing, but utilizing ChatGPT or other tools as part of their professional practice? What other challenges does that throw up if you simply don't know how that information is being used and integrated with other systems and other data?
Yeah, look, it does throw up challenges, and I think really a lot of these challenges go to the question of how familiar the teachers are with the AI tool and how it works and what it does and how to make it do things that you're wanting to do it, and how to make sure that you have that capacity to shape it well. Just in a more general sense, it reminds me in a sense of, let's say, when the piano was first invented, and suddenly you had this thing which could play any note on the scale, and anyone could come along and play it. And you can imagine they thought, "Oh, great, I can play chopsticks." But on the other hand, chopsticks wasn't what made the piano great. It was the fact that Mozart and Beethoven and whoever else could compose these wonderful things, and it was the capacity to really engage with the instrument and explore its possibilities with human creativity that turned it into something fantastic. And I think that's the same with AI. Sure, we can find this little way of helping us. But unless we engage with it enough and understand its capacity and understand what its limits are and what it's good at and what it's bad at, I don't think we should be using it in a professional sense. So I think we should be using it in a professional sense, but I think that means we need to learn the piano, as it were, not just play chopsticks. And in this, just to come back to your question in relation to decision making and procedural fairness, there's duties to in decision making, whether it be, let's say, decision making about disciplinary issues, either about students or staff, where the decision makers need to allow the other person against whom they're making a decision to have a fair hearing, to not be biased, and so on. Now, I think these are areas where, although you might get decision support from an AI, it really is it needs to be very clearly the human who's making the decision, and knows how the AI works. I had a little play with this beforehand, and try to put in I'm a deputy principal in a New South Wales government school, adopt the role of my legal researcher and disciplinary advisor, research disciplinary penalties for New South Wales government schools and powers under the Education Act. What would be a fair penalty to impose on a student who admitted bringing 1 gram of marijuana to school to sell to other students? So that was my question to a chat GPT, and it gave me what I regard as a very good starting place answer. I'm not going to read out the whole thing. It's quite detailed. Then I asked a follow-up question, gave me, again, a very good answer. This was actually it's probably ChatGPT 4, which is part of Bing. And, so I think there is, if I'm wanting to do something quickly, getting my head around an issue like that, it can be very helpful. But I wouldn't want to rely on that, and I'd still want to be talking to legal services or the lawyers who might advise the school to be making sure I'm getting the decision right. But it's a good way just to kind of, I was surprised how good this answer was.
It's funny you highlight that and the accuracy of it, because I am aware of a relatively recent, I don't know if it was actually an academic study or more of just a survey, but there was studies, or there was a group that put ChatGPT's ability to help patients with medical diagnoses, and found that it significantly outperformed human doctors, not only in the accuracy of its diagnosis, but also that the patients preferred its manner in responding to questions, and it got a much higher rating on bedside manner. So it's interesting to hear you talk about the accuracy of it in processing like legal and decision-making processes in schools, because it is very quickly in a number of industries. I think getting similar results.
It makes sense to me. I assume there's still a doctor and not just an AI treating those people for their cancer or whatever it might be. But, yes, if it can pick up a false negative, in other words, if you test negative for the cancer screening or whatever it is, and you would have been told by the doctor that there's nothing to worry about, but it can find something that the doctor missed, and really you do need treatment for it. It seems there is a duty to use it if it's better than doing that. That seems to me where the standard of medical care would go to, so long as you know that that's more likely than not. You've got some way of determining the standard of the decision maker. So I think in those cases, the AI needs to be trained very carefully on the right kind of material to reach that kind of standard. But it wouldn't surprise me that it can exceed human judgment capacities when well trained.
Well, I realize this is getting off topic a little bit, but I bring this up just out of sort of curiosity to see what it might do in education, because my understanding is that, and to go back to your example about cyberbullying, where you sort of suggested that it would be trained and bring up caveats about this looks like inappropriate use. My understanding was that in that medical context, it similarly would say to people, you need to see a doctor, or this is not full proper medical advice. It was programmed to give those caveats, but still engage with people. And I wonder what that might look like in an educational context, especially when we live in an era where teaching practices are so contentious and where, the debates about what constitutes effective evidence in education are
Yeah.
currently quite contested. And so that kind of caveat-driven
Yeah.
providing of
Look,
information would be interesting to
the
see
example I just
in an
gave in
educational
relation
use
to
as
this
well.
student discipline issue, again, both of the responses that said, please consult with your school's legal advisor or the Department of Education for further guidance. So, it doesn't want to
Yeah.
give advice willy-nilly like that. It wants to cover itself, which is sensible. But I still think it's a pathway to help understanding and help decision making, so long as it's not the final thing. Certainly at this stage. But I think if you weren't in that doctor's case, you could get to a point where helping teacher judgment and pointing out, I don't think you've got that right. Think about it again. Might be something that is worth that it can enhance. It can enhance, so long as it's not the final decision maker. I would say. I mean, yeah, a legal person. AI is not a legal personality. It can't be held legally accountable for something. A human is, so a human has to take responsibility. So ultimately, well, when I say a human or a legal entity, like a government department, which is headed by a human.
Well, that brings us to the last topic on this list here that I think is quite an interesting one. And I want to preface this by bringing up another example from, again, about 8 or 9 years ago, when Microsoft first was trialing earlier generations of AI chatbots on publicly available information. And there's quite a famous story that they used Twitter because it was one of the largest repositories of public-facing information as the training data for this chat AI. And very quickly, it basically became a hugely racist and sexist entity because of the volume of content that it accessed from Twitter. And similarly, these AI chatbots, now obviously a lot of work has been done to balance the way that ChatGPT engages with, we keep saying ChatGPT, but the way that AI models balance this stuff. But it does raise the issue that the AI models are trained on data and that data may have a bias or that may have a skewed perspective because it's either all from a particular cultural perspective or sometimes even from a negative perspective. So if teachers are using it, or even if students are using it, how does it raise potential issues of discrimination if the data set informing the model is skewed? Like what
So
issues
look,
does that
I
raise for
think there
teachers?
are discrimination issues, and I think, as you say, the models have been, I think people have become aware of that, and they've tried to train the models on a wide diversity of things of information. But it could be also about not just what facial appearances are about, but it could be things that people of different diverse backgrounds are culturally interested in, their cultural practices, a lot of different things like that that might be that might tend to treat people disadvantageously on the grounds of, let's say, race or sex or disability and so on. Now, one of the obvious cases where it comes up would be employment decisions. If you are using the AI model to help you cull people for an interview or something like that based on the quality of their job application, that could be done on, if there were biases in the way it did that, that could be indirect discrimination. So you're treating some people less fairly on the grounds not directly on the grounds of race, but you're in effect creating an unseen barrier which correlates with race and is therefore, or sex or whatever, and is therefore harder for a person of the protected class to compete with. That's called indirect discrimination. And I could see that if there were unconscious biases, let's say, within the material, that would be a problem. And I think it might be I'm not sure how this will work, but one of the issues to be assured about is if schools are contracting with companies to have a protected system, like, not a non-hackable system, and to train the AI on that system's own data, that maybe you will reintroduce some bias because of the particular distribution of people that you have within your system. So that, for example, if there was a school that had predominantly people of a single race or ethnic background, it might be discriminatory against people who are not of that background, because most of the material in their own internal environment that's being trained on are of the dominant background. So I think that's, again, something to be aware of, and there could be discrimination claims on that grounds. The other thing, I think it's potentially also very helpful for people who are, let's say, people with disability, that there could be better ways of using through AI of making material accessible, providing access to students, providing gradation of material that is suitable for a person at the level that they are at, and to extend them along those ways. So I don't say it's all danger. It's always a risk of benefit and risk, I guess. A mix, yeah,
And I suppose, something that we didn't bring up at the beginning, but that does highlight something that's come up in a number of interviews I've done in the past, which is making sure that people remember what this current generation of what it's being called AI,
yeah,
but really the phrase large language model
yeah,
is the more technical term. And I think it's worth reminding everyone that these programs don't have anything we would call an understanding. They have a statistical view of language of, if I say this, what's the
yeah,
most likely word to come next in the context of your question. And so, that idea of training that you've brought up, the platforms themselves don't have anything we would call an understanding of those issues of race or of sexuality or of gender, or even an understanding
yeah,
of what policies mean. What they do know is, in that context,
yeah,
here's the
yeah.
thing most
That's
likely to be
right.
said.
There's some interesting philosophical questions there about when have
Michael,
we
is it?
got to consciousness or intelligence, and what are the different philosophical models of consciousness and intelligence. I won't go down that rabbit hole, but yeah,
when we start seeing an AI model, you know, pursuing its own legal status in the courts,
that's
we'll have a
right. When
whole
is
other discussion
what
to
counts
have.
as a human? Is it? Yes.
Michael, are there any other
Look,
general statements or advice for
I
teachers that you
suppose
might
I would
have
just
about
come
legal
back
issues
to
and
the
AI?
idea that there are general duties of care, that the duty of care, and a lot of these ideas apply to most of the areas that we've been talking about. The duty of care will evolve with circumstances. Let me just come back to, if you look at the policies that school systems generally have, they have evolved through circumstances. We've got policies of inspecting trees because of a tragedy that happened when a tree fell over. We've got policies for preventing anaphylaxis because of a tragedy that happened in a school. We've got policies for safe swimming because of a tragedy that happened to a student. These instances weren't necessarily foreseen by the people involved at the time, but we learn from them and we have to keep evolving. So we have to, if this is evolving very rapidly and exponentially, we need to be looking all the time at, what's happened, what we thought this some time ago, what do we think now? And I think the rate at which you need to keep revisiting uh, the what counts as reasonable and what the right policies are is more rapid because of the rapid development. So I know the national framework says this will be revisited and reviewed every 12 months. It also says more frequently at their discretion. I think if you look at how much has changed in the last 12 months, no reason for me to think that there'll be less change in the next 12 months. If anything, we might be, in the rising part of the exponential curve. And I would be looking at these things more frequently. I would be saying every term, until we see whether things have, If we look at it every term and it's the same as last term, let's not worry about it. That's fine. But I would be looking at it frequently, and I would be making sure that there is expertise, that we're not the schools have enough experience by teachers who are engaged and have looked at how the AI work, have played with it, have learned it, have known how, have developed techniques of using good prompts, developing a continuing understanding of what the capabilities and what the risks are. I think it's important that there's a corpus of knowledge in every school to do that. I'm sure there'll be a mixture of people within the teaching profession, those who are very interested in do that, and those who, there's so much change, I'll wait until they tell me what to do. And I think the more that we can bring the latter set towards the former set, I think the better off schools will be in terms of responding to and having a good sense of what's a reasonable way of managing all this. There's not one answer at one time. It has to be revisited.
Well, maybe we might need to revisit this conversation in 6 months
with
with
then, but now
here we go.
I'd have known this. Yeah.
Yeah. Well, Michael, for anybody who'd like to follow your work in this area or to learn a bit more, is there anywhere you would like them to go?
They can find me as Michael Waterhouse on LinkedIn, or I have a website which is waterhousemediation.com.au. I'm a mediator primarily, so if they're interested in that, that's fine. But also I have on there seminars that I provide from time to time for schools if people are interested in that. They're generally provided online.
Excellent. Well, I'll make sure there's links to both of those sites and your profile in the show notes for this episode. Let us hope that any teachers that engage with your work do so more from a professional learning sense than as a mediator. But anybody who wants to find out more can find those links in the show notes. Michael, thank you very much for your time and your insights. As I say, we may need to revisit this conversation in a short period of time if things do change rapidly.
Thanks very much for having me, Cameron. I've enjoyed
Thank you again.